Let's say his date, I don't even know anymore.
17, no, 16.
16th.
All board members present.
July 16th, all board members present.
I'll move to go into executive session.
Second.
All in favor?
Aye.
It'll be spoken to.
Nice seeing
Tell
you.
him to come to the door.
Was he a former DA?
Tell him, let us know.
Was he a district
He
attorney?
was a former.
Okay, guys, you're back.
CBA, former county attorney,
All right.
has been,
10:18,
Not the
Supervisor,
county
we're out of
attorney,
executive
attorney.
session.
I move to close the executive session.
Second.
All in favor?
Aye.
We'll resume our work session. Where's Frank? Here's a question here I got on this.
Let me get him, it's outside. John, can you go scrap him, if you don't mind, please? He's right outside the door there.
What do these guys set this thing at? It's like 40 in here.
Patrick, it's like 80 in here. I'm dying, I don't know about you guys.
Christ, it's cold.
No, it's open.
Have a seat. Okay, well, you can bring it up to the supervisor.
This memo on Whisper Landing, you want to explain that? It comes from Elaine Leonard. Yeah,
What I want, yes, what I asked Elaine to do was, we're done with all the processes as far as the Board of Appeals, what they could handle, and the, as far as in the application for the special exception. Currently, the applicant is before the Board of Appeals for a height variance and for some other variances for disturbing environmentally sensitive lands. The Board of Appeals cannot go forth because the lead agency in this case is the Town Board for CEQA, and you would have to adopt a CEQA before the Board of Appeals would be able to render a decision. This gets down to the heart of the matter as to whether or not you wish to approve this particular application. And so, at this point, what I was trying to convey to the board was that this matter is now before you and back before you, and we need to know, or would like to know, how the board wishes to proceed with this particular matter.
Well, is the BZA closed their hearings?
The hearing's closed, but they can't act.
They haven't made a decision.
They can't.
So
They can't.
if we don't know what the BZA is doing and what they're gonna let them do or not do, how can we act? Can we get a sense of what they're gonna do so we can make the proper decision one way or another?
I think what, this
For us
gets.
to act and all of a sudden it comes in as 5
We
stories.
seem to be caught in a catch-22 here.
Right.
The Board of Appeals can't act until they adopt a CEQA. But in this particular case, this is a unique case. This is a special exception which comes before the town board, and pursuant to state law, once you're in the special exception provision, this, I think it's 274A of town law, what you basically do is make an application directly from the, from the town board's hearing to the Board of Appeals for them to hear the variance case. But the Board of Appeals would normally be the lead agency for most special exceptions. But in this particular case, this unique case, because the special exception is before the town board, you are the lead agency. So the Board of Appeals can't act until the CEQA determination is made.
But the catch-22 is, we don't know what they're gonna try to say okay to. Unless we get some sort of directive from them, a sense resolution of some kind stating to us what they're going to do and what they're not gonna do, because I don't think it's fair to the town board. Also, when we find out it's a 5, 6-story building, and it was originally gonna be, 2.5.
Okay, I could ask the Board of Appeals for something like that. I could work with the town attorney, and maybe we could get something
I think you need
legally.
to work with the BZA attorney also, because
Okay.
realistically, they have their own attorney, because at times, the town has sued the BZA. So we have to be very careful he's the attorney for us, the
Well,
BZA
at this
attorney's the attorney for them.
At this particular point in time, one of the issues that I'm trying to raise is that this is a matter that is some discussion before the board. And rather than have another board enter into it, the key issues are whether or not you are going to approve it or not.
You're looking to know whether or not our sense is to let the secret process take place.
That's correct.
Okay.
But Eddie, as you said in the past, we approve secret, approving secret is tantamounting to approving the resolution. You said that like 2 meetings ago. So we have to be very careful how we act without knowing what the BZA's feelings are on the matter.
Anything that would come up that's objectionable would come up in a secret by our Department of Environmental Ways.
Well, I think there's two basic issues here. You're correct, there is environmental issues that of significance because of the disturbance of environmentally sensitive lands and other things that are relevant to that. But there are also issues with regard to, that are the special exception criteria. And that's really a matter before this, I believe, in my sense, is a matter before the board. The question, for example, let's take the height of the building. It is one of the special exception standards that is in the code for a assisted living facility that you deal with height. It says it right in that, one of the criteria. So, in my view, that's a board consideration, nobody else's, that's.
From my understanding, correct me if I'm wrong, didn't they go back in and lower the building to conform?
They lowered the building, but there's still height issues with the building.
They
More than
said three,
35
they
feet?
still want to be 3 stories,
And 3
even though they want to be
stories
under
is- yeah.
35.
It's 3 stories, that's a height issue as well. That's correct.
So they have to meet the special exception. So right, as of today, do they meet the special exception criteria?
No.
Okay, the CEQA process, right? And I go harken back to what Tom just said. How do you do a CEQA if you don't know all of the facts of the process? What are we going to review, or Russell Barnett, the proposed variances?
Okay, if the board is of a mind saying you don't have sufficient information to act right now, then yes, go through the CEQA process. In other words, if that's what the board is feeling, then you're directing that the CEQA.
No, that's not my question. My question is, a CEQA process takes into account all the facts regarding this applicant, any applicant.
Right.
Now there are 3 or 4 variances that are out there. Do they include those 3 or 4 variances in their determination?
Yes,
They do, right?
yes.
Okay, so, all
That-
right.
In other words, it's part of the CEQA process has to review that as well.
Okay, so if the town board says, okay, send this matter secret, they will take into account all the facets of the hearings, et cetera, et cetera.
That's correct.
But I would like to have a sense resolution of some kind from the BZA in that secret process, so they know also as part of the process what they're doing, because there are environmentally sensitive lands there.
This is, yeah, the assistant.
Will the BZA give us that?
Frank said he'd asked them for that. I think we really need to be informed, and Russ needs to be informed when he's doing secret, where the BZA is going with this.
I will seek an answer. The best, I thought the board would want, my issue here was I thought the board would want to send it to SEQA and finish the process, if that's what you wanted. But before you do that, I think what Councilman McCarthy is asking, you want to know before you make that decision what the board is feeling about the variance.
I think our environmental department should have that as, that's part of his review.
Okay. Then I'll seek from the board some sort of sense and see if they can report to the board. And I think this communication is relatively valid, by the way, because the process is, it's in state law, and there's 274B, that you're in the special exception process, and it does address the issue of variances going to the Board of Appeals. So I think in this particular issue, I think the board has a right to ask for something of this before you act.
Okay.
I think it's implied in there,
You're
so,
going to check with Mr. Hennings? He's
yes,
our
I will.
attorney.
And I'll check with both the
then
chairperson and.
Get back to us.
Yes.
Okay.
Okay?
Okay, don't go away. You wrote everybody a memo regarding funds available to update the LWRP,
Yes,
and you just need to know whether the board wants to proceed with that.
yes. If I could explain that.
Okay,
We've had a lot of issues with regard to the LWRP that the board has been concerned about over the years. House size, commercial areas that we have along Jericho Turnpike, piers in the river, and things like that. And what I've mentioned to at least some of the board members, and maybe not all, that we need to update our LWRP. What has been one of the sticking points of updating the LWRP, and remember, we did the first LWRP, so the regulations have, or the procedures have changed since we first adopted ours. One of the caveats now to a contemporary LWRP is you must have what is called a harbor management plan. This, in and by itself, was an added expense that would be on top of any update of the LWRP and make the cost really in the neighborhood of between $50,000 to $100,000. And that has, the board, because of fiscal reasons, has been reluctant to commit to that. The state has a program out under what they call the Consolidated Funding applications, I think, or,
Frank, if you want to.
okay, which is, they're funding a lot of grants through this one process, which is due August 14th. The decision or the award of these funds would come in December of this year. Okay, thank you. Okay. Elaine, it's the consolidated funding.
Consolidated funding application.
Okay.
It's due August 12th.
Okay.
Before the next meeting.
Okay, we call it the CFA, and there's a whole wide variety of applications that are coming in on this, and there's from other towns, and it doesn't involve just LWRPs, it involves capital programs, it involves parks and the like. But when we attended the conference, the one that we felt had the highest rating for the town was updating the LWRP, and in fact, we actually spoke with the state people on this, and we think we have a high chance of getting this. What this fund would be is basically somewhere in the neighborhood of, I'm ballparking it right now, about a $60,000 grant, of which we would have to come up with about half of that amount for funding to update it. As I see it, this is a good bargain for the town if we want to update our LWRP. We have constant arguments with regard to piers and house sizes.
Dredging.
And dredging issues and other things.
So, Frank, let's cut to the chase. You're asking the board to
For,
allow you to approve the grant,
I'll apply for the grant
apply for the grant, and knowing that we're gonna have to match the grant at 30,000.
next year.
Yeah, okay,
Okay, that's
I'm
basically.
fine with that.
I'm on board.
Absolutely. It's long overdue,
Okay.
as we have discussed it.
Conditional discharges.
Yes. Before we get
My
to that,
opinion is, I read your, it seemed to me that
No, Frank, you stay. Has
it
something.
should be a very important matter before
Okay, who's gonna
the
make?
town board have that, well, the town attorney's office, well, at least my opinion.
My opinion, I'm sorry, I didn't
Go
interrupt you,
ahead.
would
Let-
be your prosecutor, Matt, the town attorney, and your deputy. Say, hey, listen, here's 52 cases. These are all sheds, decks, all miscellaneous. They don't need to go to the town board. But here's KPE 3. This needs to be discussed in town board. So then supervisor sets a meeting for that particular one. But I don't think we need to see
Well, but,
conditional discharge on sheds and
but-
decks.
I think his question is, and he's right, you're giving him authority
Here's-
to settle out, it's subjective what he thinks is a biggie or a small
And
one.
that's the problem,
Yeah.
because you don't want to be
Yeah.
attacked or have Martin attacked or something, because we made a, entered into conditional
Yeah.
discharge of something that we didn't think was significant, but someone on this board feels that it is. I think the answer would be, and bring them all in, and we'll just go through them, these are the 10, 15, 20 we have for this 2-week period, and they say, not important, not important, not important. So you, board, because then this board would say, you showed us those shed, those are not a significant fine, and that takes 2 minutes to go through it, but at least you know what we've got. And then if there's two that you want to discuss. But I don't feel comfortable if you, being the one who's going to select which ones are important, because the board has indicated they want to look at them. But I don't think the process of going through them, the simple ones will take more long than a couple
But I
minutes
think the
anyhow.
board, and I'm just speaking for myself, has a town attorney, a deputy town attorney, and a prosecuting attorney. If they can't figure out that sheds, decks, fences, garbage maintenance on a property of a front yard, clean up, if you guys, the three of you, as a committee, can't say, we're not gonna bring these to the town board because it's ridiculous.
But-
I mean, you have three attorneys that should be able to make that
But here's-
decision. Three, you should be able to pick out. And if you can't, I'd be very surprised.
And I understand your point, but my point is, I don't think they should have to come to the board at all. So if you want to look at them, then look at them all, because I don't want to have this board saying, well, you shouldn't have done one of these when I thought it was insignificant. And my point is, if there's, just say, we have 20, I bring them to you, these are the 20 that we have, the minor ones, the ones that you don't want to know about, they're going to be gone in a minute. You just say, oh, it's a shed, we don't care, but at least you've asked to participate in the process, then participated, but I don't want to be the one, because I don't think I should be doing it in the first place. I'm doing it because the board suggested it. But
Well, I'm trying to say, we do have some confidence in you to do all the small ones yourselves, that you, the three of you as a board should sit down and say, and we'd have to live with that decision as a board, saying, these are important topics that should be brought to the town board. I don't know how the rest of the board feels, that's my opinion,
Well, this in the past has been what you've been doing, right?
after the
Very-
fact.
Very rarely, I mean, I'm here, this is my second year, I was here for 10 years past, and never brought a conditional discharge to the board.
But I mean, you made the decisions on the conditional discharge.
And we know what cases are important cases.
And now what you're saying is you want to bring them all here for us to review.
What I'm saying is, I don't want to bring any of them
I
here.
think, John, I
But
think
I
what
don't
he's
want to
going,
be
excuse me,
second guessed
Robert.
on the ones I don't give to you to look at, because someone will say, you should have shown us this one, and I would have thought it was not significant.
No, previous discussions in work sessions back were that you bring them all here.
Right.
That's what was said at
Right.
this table. Bring them all here and we'll determine it, and that's what
But
you're
I
saying
don't
now.
think it's gonna be a terrible burden, because, again, the simple ones, we're gonna look at and say, we don't need to do it, we don't need this one, and that's gonna be going through
Right.
maybe 10 or 15 in 2 minutes. There might be
done.
one or two. And it might
I
end up
think we're
being,
making a mountain out of a molehill here. Okay?
but you understand, all I'm saying to you is, I work for this board, I take direction from this board, but if I don't give them all to you, what could happen is someone will say, how come we didn't bring us this one particular one? I would say I didn't think it was important, or Matt would say I didn't think it was important, or Martin, and then someone on the board thinks it was important and we should have brought it to you, and then I'll be attacked for not giving you that one. I just think it's simple. If you're gonna do one, do them all. I don't think the time on the minor ones is going to be a big deal.
I happen to
But
agree
keep
with
in
the
mind, Mr. Supervisor-
I happen to agree with the supervisor. I think, I have enough confidence between Mr. Valentine, yourself, and your deputy that you would know
Exactly.
when there is an absolute important
And we're saying-
conditional discharge.
And we're saying we're willing to take that risk.
But I understand what
Especially
he's,
Mr. Valentine's included in
I
it.
understand what John's saying is, a couple of work sessions ago, it was said at this table, bring them all here.
No, it was
we
never,
wanna
I never
see them
said
all.
bring them all here.
We
I
wanna
said
see
the
them all.
important ones, because I'm the one that brought it up first.
Okay, but
It
I'm,
was always
If I'm
the
going
It's not
important.
the way I
to be
understand.
Brought into this,
Good.
then I have to side with John. Because the reason why we're having
Well,
this
wait,
discussion
this-
is
this-
because we've been
This
second
discussion
guessed
is
on
out of
conditional
hand.
discharges.
This discussion is now out of hand. Why is John being brought into this, and why is he sitting at the table?
Councilman Wareheim brought me into
But what's the
conversation.
point? It's a simple matter. Tommy proposed, or Mr. McCarthy proposed, having a review of conditional discharges. Well, I've determined here this morning, I don't find that necessary, based on what you've just said.
See-
So why are we continuing here? And Mr. Wareheim agreed with me.
I do.
See, I guess I'm somewhat confused. I don't think I should have to come to this board at all with
Well,
these.
you just had two board members that agreed with you, so why don't you just get a sense of the balance of the board and stop the conversation if there's three people?
Does this board want me to bring conditional discharges to it to review before we enter into them?
No.
I'm going to leave it to your judgment,
Yes.
that what you might think is, look, we're not stupid people.
No, I know, then that's,
What you might think
You
is
know
a
what
major
my-
case,
right.
then with
Okay.
John and yourself,
That's
I think it'd be
fine.
important
and
for you
that's,
to do
and
it.
that's typically what was done in the past. I mean, if
Well,
I
there
have a
were-
case that's sensitive, I come to the board and say, we have a problem with this, and so if we just leave it at that, so we're not really changing anything, we'll just leave it as
But
it is.
if there's a major case, you know what major cases are. You know, like the Carlson $1,000 fine was ridiculous, you know that.
I just
That was
don't-
one that should have came to the board.
I just don't want to set myself, my office, or public safety, or building to be in a position to be second-guessed for something that we don't think is significant, yet someone on this board does. But I will use my discretion. If there's something I have to come to the board
And
with,
then
I
you'll
will.
get second
Right,
guessed.
that's fine. But at least I put myself in the arena. That's fine.
Kind of like what I just said.
Okay, moving on.
Okay.
You all agree that we should spend $45,000 to buy generators for these, United Cerebrally Palsy Group Homes in Smithtown?
That's out of
Yes.
community
With
development.
community
money.
development funds?
Yes.
Yes.
That's done, Frank, take care of that.
That's out of community development money, the excess money they had.
Okay. In this Wisconsin Fire Department matter that was brought up 2 weeks ago, or 1 week ago, I don't remember, about the piece of land, you
Right.
suggested it?
Yeah, I sent it to everybody, a copy of the maps. Everybody has already, Frank just brought these with him, I didn't know he was gonna bring them, but everybody already has a copy of these maps. I think everybody here pretty much knows what the project is. It's basically, the project process is, go out, get an appraisal, see if you can negotiate with the owner, property owner for the appraised value, and then if you can't come to an agreement, then go to eminent domain.
As Councilman McCarthy stated, that's right, we can just go right to the person who owns it, figuring out if the town board was of a mind to, and that's really what my memo was to the board, was kind of get a sense of this board to see what you wanted to do. I apologize to anyone for any misunderstandings that came out of that memo. Everything was above board, and there was, it started out with Nesconset Fire Department just making an inquiry about what they could do, and then it languished, didn't move too quickly.
But the point, I think, that brought, I don't want to belabor it to the head, was that your memo said that they were paying for the cost of the eminent domain. The fellow that got up here, Mr. Critelli, disputed that and he walked away. But Tommy said to the board in memo, we ought to do that on our own. And that's where, now we need to find out
But-
what's the best way to do it on our own.
There's two things we could do. One is, we should prepare an appraisal,
Yeah,
get a value of the property, and then we should try to just negotiate with the person directly to say, we want to purchase this property for the improvement of intersection of Lake Avenue, Gibbs Pond Road. If the person doesn't come forward, and I understand that Nesconset Fire Department had written to the person several times, and I don't believe they ever got a response. That's what I believe, I could be
Okay.
incorrect. So if we don't get a response, then we have to proceed with the proceeding under eminent domain law.
Mr. Supervisor?
Yeah.
While you were having your executive session, I met with the property owner and his architect outside. Yes, sitting in the back. We were discussing negotiations with Councilman McCarthy suggested, and what we came to a conclusion, I'll just summarize it. What my office is going to do, the applicant is interested in building a medical office building. We're going to, Peter Hans and my staff is going to work with the architect. We're going to design something, see what's left over, and see what we can do about getting this for
and
the...
get it donated, what's left over.
We're going to try to make that as
Just wanted to
What-
plant the bug in the owners, he's in here.
What, I think the only issue that's going to come up, and I think we're going to get down to this, and I'll speak with John about, is in the end result, we're looking at this property, the highest value that we think of this property is what we call sewage flow rights, which 3,000 square feet, it's a tenth of a credit or whatever it might be. So we're going to work
It
out.
helps.
We're going to work this out, and we'll come up with what we consider to be, and if we can come up with the cheapest possible alternative, or with that, we'll come up with it, and we'll report back to the board. We'll have it done in a very short order. It's not that complicated.
Great. The only thing I have a question on, Frank, how did this languish from March 12th, and I just found that board by accident in the town attorney's office and saw this conceptual plan. That's a year and a half it languished nowhere in limbo and nobody knew about it.
Well, we didn't know about it. I didn't know about it myself until I was talking actually to...
It came out of your department, though.
Well, it came out, there was discussions with Peter Hans and my staff
Right.
and concepts about it, but there wasn't somebody formally coming to my department. I mean, people come to my department all the time and discuss with staff members about how to do something, and staff will...
But it's kind of like the same thing we just talked to John about. If you think kind of might be important, maybe just send us a memo.
Well, I didn't learn about, I'll be honest with you, I didn't know about this till actually 3 weeks ago in an
Huh.
official concept.
Okay.
Pete did mention to me at times in the past that he was looking at this particular issue. I didn't think it was going to become that...
I understand.
big
Hindsight's
a-
20/20.
Big of an issue, because it was just really clipping a corner. That's really what, it's a road widening, minor road widening. So we do this all the time. We have streets that we're trying to realign or trying to work on, and I just have the staff just complete whatever the actions are. And they do, 99% of the stuff is routine. You don't even see it when we widen a road or change a curvature or something like that.
Okay.
Okay?
Okay. Next issue is your memo on the MTA case, John. You write that our counsel says it will be a difficult appeal, but an issue worth pursuing. So it's been lost in the Supreme and the Appellate
In the
Division.
Supreme Court, the application was granted. It was reversed in
By
the
the
Appellate
appellate.
Division. Now, council, Nassau County, and different towns and are going to be pursuing an appeal to the Court of Appeals. And Craig Rizzo and the law firm handling it, we spoke to him about it, and you're probably looking at about $10,000 in legal fees and expenses to work with other towns in the county on the appeal. But I think, and this is the board's decision, I think you've come this far. I just didn't want to say okay without the sense of the board on it. I just think you've come this far, and we have some decent arguments at the Court of Appeals.
One of these?
How many other towns are involved or will go on board again?
I'm not sure of the number.
Do we have any sense are going to continue the
Most
appeal?
of the,
Oh, well,
most
when I
of the
spoke to
towns in
Craig-
Nassau County,
When I spoke
correct?
to Craig Rizzo, most of the towns were in Nassau County, and they were all going, and we would be the only one to opt out. And his concern was, if the town of Smithtown decided to opt out, it might just be an issue that would be picked up by the Court of Appeals, saying, see, one of these towns doesn't have confidence in the appeal. That was one of the things that we talked about.
Well, I agree with you. We've gone this far. Huntington joined us, I believe, Brookhaven,
Yep.
in the original case.
Well, yeah, but that's my question.
Right.
How many
I have
towns?
to go get the caption, I just don't
Okay,
remember the
all right.
Just have to go get the caption. So I'll get the caption.
But let me then ask you this question. Assuming that one or two towns in Suffolk didn't pursue the appeal, Nassau's going to go ahead
Right.
anyway. And the impact of that would be affecting everybody.
And again, my sense was, I'm always conscious of the outside counsel fees and the money that I expend on these things, and Nassau County has a much larger fund to draw from, I would suspect. And if they're going to go to the Court of Appeals, we could benefit from their going without having to expend the money. And that's really the only thing my sense was, from business point of view, they're going to go there. If they win, we benefit. If they lose, so be it.
I think it's more philosophical on part of Suffolk towns than it is actual loss. For example, I think our cost here for the town is $110, $110,000. The Smithtown News would charge $60 because they have 2 employees for the year. So it's a philosophical objection to state intrusion into towns that get no real benefit from the tax.
So I told Mr. Rizzo I would get a sense from the board and report back to him. My only thought was, and this is just, you've come this far, you've participated, you've spent a significant amount of legal fees to date on this case. To just drop it is...
What do we spend so far? Do you know, offhand?
Probably about $20,000.
About 20.
My opinion is you keep going, because it's
agree.
not fair.
All on board
That's,
with
that's
that?
the
agree
basic
with
reason,
that.
right
Yeah.
there. It's not fair, we should continue it.
Okay, we're continuing. John?
Okay.
We've disposed of this one, this memo here, John, with the reviewing of the conditional discharges.
Yep.
Will still bring us major cases, though.
I called you this morning on this one, John. Oh, go ahead. Go ahead.
Just-
Patrick, it's Frank to speak on, the one you had there also. I gave him a copy of that. No, it's all right.
Supervisor,
Yeah,
the case that we're involved on, the one we're talking about right now for the MTA, there was a separate case that was brought by other towns. A lot of them were Suffolk County towns. And that was dismissed in the Supreme Court. So we were in an action with mostly Nassau County towns. And there's about, I would say 15 plus or minus petitioners on the case, most of them from Nassau County. Because the county, when the Suffolk County case was brought, that one was dismissed. So we were fortunate to get this case. That was brought in Albany.
right.
This
I do
case was
remember
commenced
that.
in
Right.
Nassau County, and it was before Justice Cousins.
Okay.
And so we were able to survive the motion to dismiss in Supreme Court, but unfortunately were reversed in the appellate division. So a lot of the Suffolk County towns were in the other case, which was dismissed in the Supreme Court, but that was commenced in Albany. So we're kind of fortunate to get past Justice Cousins, and but most of these are Nassau County towns.
Okay, so,
I'm
but
like-
we've made the agreement that
Yes.
we're continuing, right?
Okay, yep.
Yes.
John, I called you on this morning, and I can't for the life of me
Yeah.
explain it or understand it. Yeah,
I guess on this instance, this has to do with the LWRP and variances. I had been given 3 different cases, Gress, Scheberg, and Vogelsberg. These are people issues involving the LWRP, and a question was asked, is either by Councilman Wareham or Councilman Creighton, what can the people do because they want to build a house that exceeds the amount permitted by the town code
Right.
and LWRP.
Okay, right.
And
But, John, that memo is addressed to their outside counsel that's representing those people. It should have been sent to the town board.
I did.
No, it's sent to.
no,
Ms.
I sent a memo to the town board
No,
on July
you
5th.
also sent a letter to Vincent Tramarko, who is their attorney, telling him what's wrong with our codes or how you can beat our
No,
codes.
that's not really accurate.
Well, and also you're talking about a BZA member. Mr. Hennings should have been answering some of these questions, not the town attorney. Because I said at times, the town attorney has to sue the BZA. This is a BZA
Did you
issue.
read this letter?
Yes, I did.
Did you read the memo that I sent June 13th?
I read the memo, I read all my memos, so
Okay,
I don't have it in front
I
of me. But I
sent
just
it-
gave Frank the one, which I don't understand why we're sending a letter to Mr. Tramarko citing cases and telling him what's wrong, how he can prevail on his cases. It just doesn't make
It's
sense to
not-
me. And
I-
it's a BZA issue. We shouldn't be involving ourselves in a BZA
But the-
issue.
But the LWRP goes to the town board, and
But he's asking you, basically, can the BZA do variances on these? That's a
And-
BZA. Mr. Henning should answer that question, not the town attorney. You're two separate boards.
I would disagree with you on that.
I can understand that, but I disagree with you also. That's
All
why I
right,
asked
but-
Frank to look at it.
If you don't mind, let me get an explanation in the memo. I did call. So you're just explaining with the applications for the LWRP, can the BZA rule on sizes or other things?
No, can an applicant get relief under the LWRP, which is what the town board oversees, the LWRP?
Right.
You vote and approve consistency determinations.
Right.
That was the question that was asked. I'm not saying the Board of Zoning Appeals has to do anything. I'm not directing the Board of Zoning Appeals to do anything. What I'm saying is, if you want relief from building a structure that is larger than what's permitted under the LWRP and in our zoning ordinance, I believe you can go to the Board of Zoning Appeals. And I didn't reveal anything to the, to.
No, I'm not saying, I just
No.
was confused as to what it was
But
about.
the question was, can I get relief from
Size house.
dictates? The answer is yes, go to the Board of Zoning Appeals. That's all. And my suggestion was, and what I did is, I think it was June 13th, I had done a memo to the whole board, also to planning, DEW, and public safety, saying, this is what I believe is permitted. You can go for certain relief because the town code regulates the size of the houses that can be put up. And I believe there has to be a board that an applicant can appeal to. And on Vogelsberg, it has to do with they got a DEC permit to put docks in, and the LWRP said you can only go to the high water mark, so if the tide goes out, then there's no way for them to get from point A to point B.
DEC approved
And the
below.
DEC approved the lower one also. So I said, there has to be a relief valve to go see if you can get this approved. And I think the right thing to do is, if the plan department or DEW objects to the request, then the department, whether it's plan or DEW, should come to the town board and say, I want to present a witness in opposition to the application to make the town's point of view understood. I don't think it should just be a department doing it without coming to the board and saying, this is what I'd like to do, so this board is aware of it. And all I
Okay,
did
but it
was,
was just confusing to me. So just let me see if I can simplify it. Somebody comes in and wants to build a 5,000 square foot house, the LWRP says, you can't, you're limited to 3,000.
right, it's a formula, yeah.
Okay, whatever the formula is. And is your memo saying that where the town doesn't give the consistency determination, they can appeal that before the BZA?
No, I'm saying under the LWRP, it says you can build a 3,500 square foot based upon the formula that's in the code. But you want to build a 4,500 square foot
Right.
house. You can go to the Board of Zoning Appeals asking for relief under the provisions of the code that
Oh,
set-
provisions of the code, not the LWRP?
Correct.
Right.
Okay.
And and my point is, there has to be a mechanism to allow an
For
applicant
somebody to get relief. Got it. Okay.
And I believe it's the Board of Zoning Appeals. And when it comes to Vogelsberg, it's not a variance. They want to get a portion of it.
A dock.
Of the dock, which was permitted by, the DEC gave them approval for an upper and lower dock. And the LWRP is saying you can't do it, and I'm saying there has to be a relief
Yes,
valve, and it
yeah.
has to be the Board of Zoning Appeals, because if you say go to the state already said you could do it. So it can't just be, no, go away on this. There has to be an appeal
I
process.
thought the state couldn't circumvent their LWRP, Frank. That's what we went
Well,
out to with
could
the
I-
Kings Park
could I
State Hospital
address this?
property. I
Could I
would love you
address
to.
this? Okay. Respectfully, I strongly disagree with the town attorney, very
May I have that
strongly.
memo back just so I can look at
Okay.
it?
First off, what is the LWRP? The LWRP is a program for coastal zone protection. And what it came about from federal laws through the 1980s, and what it basically does is this. We are permitted as a municipality to develop a plan for the development of our particular coast, whatever it may be. If we don't do that, the state will implement that
Right.
particular program. We chose to implement that and do that. Once we prepare our program, it gets kicked upstairs. It goes to the state, and it goes to the federal government. They approve it. What that means is, it is a binding law that binds the state of New York, binds the federal government, and binds us, as well as the county, all governmental jurisdictions, in what we are to do within that coastal area. It is not a zoning regulation. It is a separate law, and it's supported by a separate law under the town code.
Well, the way that John Zoll was written to Mr. Tramarko, that would drastically affect us on development of Kings Park State Hospital. Basically, they could just walk all over us, correct?
Well, I don't think you can't, well, first off, it's a separate law. This is not a zoning law. In other words, you establish the zoning. You're given that authority by the state of New York. Under the state of New York laws, the Board of Appeals can grant relief from any of your zoning regulations. I'm not disputing that. The LWRP is not a zoning regulation. We are required by law to place certain procedures from the LWRP in our zoning code as by way of notice, but the LWRP is separate. It's a separate law from whatever the zoning is. And so therefore, the Board of Appeals cannot grant relief. Let me finish, John. From that. Now, let's dismiss one thing that's right off the bat. The docks in the river. You cannot get a variance on public use of property. If you were to build a dock, you are building a dock in the river, which is our property.
Which
You
is a
can't-
marine use permit.
It's a marine use permit. You cannot get a variance on that. That's our land,
Right.
and that's a
Okay, but wait,
completely-
could I just stop, Frank?
And let me finish, Pat, for a moment. I have, to put this matter to rest, I have contacted the Department of State,
Share?
and I sent a copy
Spin
of
it around,
John's
didn't you?
letter, and we are asking for them to give us an opinion on this, which I'd like to submit to the board, and put this matter to rest. I mean,
Make it so.
obviously, I am not an attorney, and you are going to
He just plays
listen.
one on TV.
Okay. I could,
Well, I didn't know we were gonna.
But I didn't know,
into
I
this
didn't know we were
depth.
gonna talk about this, but here's, but
Well,
I
I
just
didn't know
wanna.
the depth of it
but-
when I called you.
No, I know, but just so, on September 24th, 2008, the Board of Zoning Appeals granted a variance request to increase the maximum gross floor area for a lot in the LWRP zone from 17.2 to 20.4.
and would you like to know what that was about?
But
No, this is
Well,
the
this
important.
should be argumentative, this
No,
should
I'd
be
like to know what it's
discussion here, I
about.
wanna know.
Okay, under our code, if you have environmentally sensitive lands, depth of groundwater is less than 10 feet, steep slopes or whatever, that's subtracted from your lot size. So if you have an acre piece of property and a half of it is steep slopes, your actual effective lot size is a half an acre. What the Board of Appeals, however, is permitted to do is allow you to use the environmentally sensitive lands as a calculation as part of your lot size. That's what this is. The actual lot size for these was larger, and once the Board of Appeals enlarged the lot size, physically, it was, the lot was actually bigger than what it was shown, the applicant can build a house proportional to whatever that lot is. I don't know if I'm making myself clear on this. So if, let's say, for example, you're allowed to build a 10,000 square foot home on an acre property, and because there's half of the property is environmentally sensitive, your restriction now is half of that, it's 5,000 square feet. So now if the Board of Appeals says, wait a minute, we'll allow you to calculate the environmentally sensitive lands as part of your lot size, and we'll give you the full credit for that, you are now back to building a 10,000 square foot lot. However, the actual lot has never physically changed. And so what the Board of Appeals was doing in this particular case was actually including environmentally sensitive lands. It gives the appearance that we're increasing the house size with regard to the LWRP, but the person actually had physically the amount of land that was there. In the cases that we're discussing right now, they don't have environmentally sensitive lands, and they want to build a house that's bigger than what they're entitled to. And that's where I disagree.
And they have to be able to go to Board of Zoning Appeals.
No, that's where I
do.
do-
Have to grant the relief. But if you
No,
read
I
the
don't agree.
decision-
It's not a zoning
if
regulation,
you
it's
read the decision,
LWRP.
October 24th, 2008, the board says relief for variance for the LWRP. That's what it says.
But what the board is saying, and we understand what the board is saying, is that the person physically had the lot area that was there. It's just that we wouldn't allow the calculations of the environmentally sensitive lands. The LWRP does not address whether you calculate environmentally sensitive
And I
lands or not
and I
environmentally
submit
sensitive.
to this board that you have to be able to go to the Board of Zoning Appeals to get relief, because paddling around in a canoe in Nissacrogue River to see if you can see the peak of the house is not the way to establish whether or not it's gonna be consistent with the
The
LWRP
LWRP is only granted by this board. There is nothing in the regulations that supersede this town. And that includes, by the way, and I think Councilman McCarthy is correct in terms of this. You have regulations with regard to the Kings Park Psychiatric Center. You're the ones who make the determination of what's in that particular code. And you make those determinations, not somebody else, and no other variance procedure is in there. You have written your LWRP, and that's binding upon all other agencies.
That's why this memo scared me when I saw it.
Okay,
I said,
what
this-
I'm saying
kill
is,
us.
if you wish, and I've said this before in the past, and that's why we're going for the LWRP grant, is if you wish to change those, and I've had discussions with various board members that I would like to change the regulations a lot with our LWRP. You change the regulations. You don't grant variances from that. Those regulations are in place and they're separate from zoning.
The-
You don't use, they're not zoning regulations,
There's a
they're LWRP.
provision in the town zoning ordinance
It's
that
not zoning.
deals with the size of houses in the LWRP. It's established. An applicant has the right to go to a Board of Zoning Appeals to seek relief from that. And this board, if the Board of Zoning Appeals grants a variance, then has the ability to either find it consistent with or inconsistent with.
But here's where I disagree with you, John. Before the Board of Appeals grants a variance in the coastal zone, they seek a coastal consistency from this board. In other words, the Board of Appeals cannot grant a variance. They come back to the town and you issue the coastal consistency, then the variance is granted. So if you're before the Board of Appeals and they're going to hear this house size, it comes back to this board, because only you can issue the coastal consistency.
Right.
And that'll be inconsistent, and so therefore you can't get a variance if it's going to be inconsistent.
But I think
You make
part-
the
Part of the
determination.
problem with that is, and I understand what you're saying, we've gone through this before, is all of these properties, when it comes back to this board, before it goes to the Board of Zoning Appeals, are handled differently. Somebody gets a 5,900 square foot home, consistent. Somebody's told, no, 3,500 square feet, that's it. Somebody else is told 4,800 square feet. It seems to me that's rather inconsistent in our actions because they're all treated differently, and that's when this board gets the complaint from that resident. We went through it over on the
Councilman
bluff
Wareham,
up above Callahan's.
nobody's treated inconsistency. I've said before in the past, we have a percentage which we give to everybody. It's based upon lot size. And when we talk about the homes on Beach Hill Drive, which we have the most complaints with,
Right.
we gave everybody exactly the same percentage of house size along that street. And I said we'll treat everybody exactly in the same way. When the town board changed the regulations with regard to calculating floor area, with regard to attics, we changed our percentage accordingly. So we were treating everybody the same way. You changed that a couple years back.
Correct.
With regard to that. So we treat everybody it's a formula. We treat everybody exactly the same way. But what I'm saying is that from a zoning point of view, this is not a zoning regulation, it's an LWRP. In our LWRP, it requires us to put the constraints that we have in the LWRP. It's at the end of the report, and I'll get happy to give you all a copy of it. It says you must place them in your zoning code. But that doesn't mean your zoning, you have now the right to vary the LWRP. When you go before the Board of Appeals, the applicant could be heard. You will still, this board here will still issue the coastal consistency before it is done. And there is no ability, or at least we have no ability, and you have put no ability in the LWRP, and we might want to entertain some issues of that when we rewrite it. But you make the determination based upon your particular code. And then the Board of Appeals grants the variance. And specifically, I would say that's for the dimensional requirements. I think the Board of Appeals has no say-so whatsoever on docks.
How
None.
did DEC give a dock permit without a permit without our marine law permit, which usually comes before DEC?
We've gone through this. This is the same thing with the sand mining permit, where they say at the bottom of the permit, subject to local regulations. And I've gone down this road before, and I've said I don't agree with that particular policy. We have the Department of Federal Government of Alcohol, Firearms and Tobacco, or whatever, and we have the State Liquor Authority. We have all the other licensing agencies of the state of New York. They come to my office before the permit is issued, and they seek a zoning consistency determination. And then they issue the permit. DEC is the only agency that we have to deal with that issues the permits and then says you're subject to local.
Frank, on Vogelsberg, didn't you go out and do a survey of,
Yes, we do.
and what did you survey?
Well, what we surveyed was what was the complaint was that there were a number of docks that were constructed in the river. But none of them had town permits on them. And keep in mind that the docks are on your land. The docks are in the town waterways. So the DEC gave permits for docks. And no permits were issued by the town, and we had about, I would say, I'm going to say about 10 docks that were constructed with DEC permits on the river where they weren't supposed to be constructed.
And just, well, going back to the Board of Zoning Appeals, I'm not saying the Board of Zoning Appeals has to do anything. The Board of Zoning Appeals, through their council, through the chairwoman, can say, we're not hearing this case. They don't have to take it. If they feel that what I've recommended in my way of looking at this isn't how they want to go, then the BZA is free to say, we don't believe we have the authority to do that.
Could I ask
Yeah,
would
but wait, I
disagree.
can't understand that, Frank. The LWP says to me, I can't do this with my house.
Right,
That's the end of the tune?
yes. It's a,
He said we can make changes in this new update that
Well,
we're
we
gonna do.
should definitely make the changes. I mean, I've
what,
talked
I have-
many times with Frank on
we-
this, absolutely.
we were the first to adopt an LWRP, and there's a lot of things that it's long in the tooth, let's say.
When was that done?
1987.
Yeah, it's antiquated.
Okay.
It's the first
So-
one ever that was made.
And it was the first one in New York State, and we learned from that. And one of the things may be, and I think I've said this to Councilman Wareheim when we discussed it, I personally do not have objections to house size. My thing is more aesthetic and how it appears rather than actually the physical house size. And that's how I would have limited it, now that we see this in hindsight. And I would like to change the new update accordingly. Where you have these properties that people spend millions of dollars for, they're going to want to build large homes, and that's understandable. What our objective is aesthetics, primarily visual impact on the river. So
Okay, but without getting
So-
into that, we're all agreeing that this thing needs to be changed, and you got permission
Okay.
to do that.
But
Can I
what
add
I'd
one
like to
more
be able to do.
Piece to this as soon as you
Okay.
finish?
I'd like to be able to do is let's put this on hold till I get a response from the state of New York. I mean, I asked the
Okay.
Department of State. I'll send you a copy of the memo that I sent to the Department of State.
And
We're
meanwhile, you're
fight-
applying for the grant, to do the update.
We're doing the update, yes.
But one thing, according, it's LWRP and also the town ordinance, and I talked to Russ Barnett about it. 15% slope, after that, you're considered environmentally sensitive land. I could throw a shovel of dirt in this table, and then it's environmentally sensitive land. Every other village and town around us is either 25 or 30% slope, considered environmentally sensitive land. Even Russ said 15% is way outdated. 25 to 30% is everybody else around us is environmentally sensitive land. I mean, 15% is so little, it's ridiculous. These people are put through this hardship, but they shouldn't be. And even our DEW director agrees, after I had this conversation with him, that it should be at least 25, maybe 5. Now, I'm not talking LWRP, that's a whole different area.
Okay.
But I'm talking about, we need to address that code. And I don't know how the rest of the board feels, but 15% is way nowhere near enough. And we're going through a lot of hardship on these residents for it.
Well, two things. One is, we did bring this up a while back, and one of the things, we did make a change to the code, which may not be aware of, is what we've done is it has to be over a certain percentage of the property in order to count. So in other words, if you have a ridge on your property that's 15%, but it's only a small amount, we don't count that anymore. So we have that as an amendment.
We're getting far afield here.
Okay.
No, but it's so
I-
important. I mean, we put people through such hardships on this 15%, which is so antiquated. And like I said, and I talked to Russell about it, he says, I said 30, because everybody else around us is 30%. Russ said he felt 25. So I think we need to look at it and amend our ordinance accordingly, if the board feels fit, to help these people out, because they're getting killed on these homes, where they don't need to be. I mean, like I said, you throw a shovel of dirt, it's 15%.
Okay, we have a copy of all the codes. I think they're closer to ours, but I'll double check on that for you. But let's go back to the LWRP. What I'd like to be able to do is put an abeyance on this until I receive a contact from the state of New York. I'll happily look Councilman McCarthy into the
Well, it's up to the
slopes.
whole board, how they feel regarding changing
Well,
the
I'll
sensitive
report to the
slope
board.
code.
I'll give
not
a
just
report
me.
to the board on what the other towns are doing. They all have steep slopes.
Absolutely on the slopes.
Okay, we'll report,
Okay,
okay?
I have a read-on for medical leave of absence for an employee. That's it for me. Anyone else?
I'm done.
Anyone else? Okay, I'll move to close the meeting.
Second.
All in favor?
Aye.
Aye.